These are statutory statements by the legislature and my belief that they should guide the courts of this state. When the California legislature includes certain statements in legislation that's ultimately enacted, I believe these enacted statements should help guide California courts. So, what am I talking about exactly? Well, these types of statements include legislative findings and declarations, intent statements, and related statutory language, such as statements of public policy. These types of statements should be codified and read by the courts as part of the statutory language. When our judges and justices engage in statutory interpretation or construction of ambiguous enactments. Of course, the most effective way for legislators to be confident that their legislation will have the desired effect or outcome and their intent is fulfilled, that is, they need to use clear, consistent, and unambiguous language. However, it's unrealistic to believe that every statute will cover every situation and not have some possible ambiguity. As a result, I think the courts in this state should be guided by these codified statements. These types of statements commonly appear at the beginning of a bill, sometimes under headings such as findings or purposes. In California, these preliminary provisions generally take one or more of the following forms. First and foremost, legislative findings and declarations. Second, statements of legislative intent. Third, statements of legislative purpose. And fourth, statements expressing the policy of the state. Now, in whatever form these preliminary statements come in, they should be given great weight by our judicial branch when they interpret the statutory language that follows these introductory statements. Why? Well, in my mind, because they represent the view of the legislature and provide an explanation or a rationale for the statutory enactment. These enacted findings and intent statements could offer both main types of statutory interpretation perspectives, textualism or purposivism, as a basis for construing the statutes. For textualists, they're reviewing the text, not just the code section language, but also the other codified or uncodified legislative statements. Also, this approach allows for the purposivists to pursue their effort to understand the purpose of the legislature in enacting the particular code section or statutory language. Enacted findings or purpose statements are often the most accurate reflection of the legislative view. Unfortunately, they are often ignored or not viewed with the level of respect that I believe that they're entitled to by state judges. However, enacted findings or purpose statements have important implications for statutory interpretation. Now, these types of legislative statements should be given deference by the state's judiciary, just like some other examples we see on occasion in California statutes. Perhaps the most popular one in California that we find most commonly is this act shall be liberally construed to effectuate its purposes. Now, why is this phrase needed? Shouldn't that be obvious guidance to a court when interpreting a statute? In brief research I did, I found at least 225 code sections that contain this particular phrase in California's 29 codes. So although it's not commonly used in California law, judges normally follow this statutory guidance. According to our state courts, for example, the fundamental rule of statutory construction is that a court should ascertain the intent of the legislature so as to effectuate the purpose of the law. That's from Upland Police Officers Association versus the City of Upland in 2003, a Court of Appeal decision. The appellate court went on to say we must construe the statute with a view to promoting rather than defeating its general purpose and the policy behind it. We are mindful that statutes must be interpreted so as to give a reasonable and common sense construction, a construction that is practical rather than technical and will lead to wise policy rather than mischief or absurdity. So, do the state's courts have to accept these legislative statements contained in the California codes? No, but they're more often than not cited by the courts to perhaps support their interpretation of what the legislature intended when the courts interpret statutes. As a result, I believe that they should be set forth more often in state law than they are today, and hopefully given strong deference by the judicial branch of this state.